So for this video in our felony defense series, we're going to talk about the trial. And so now we've been through the whole process. We've got all the evidence. We've done the negotiations, and now we're getting ready for it. So the big thing to keep in mind, a trial isn't like how we argue in our homes or out in front of people. So the first thing is there's very strict rules on what can come in as evidence or not. And so we'll be going over with you what we can use and what we can't use. And so one that's a good example that comes up a lot, and it's hearsay. But most of us know what hearsay is from the movies. It's when you're testifying to what somebody else said. So you're not going to be able to testify to what somebody else said, or neither will any of our witnesses. And so a lot of times when we're dealing with clients, like what they know or what they want to present comes from what they heard from somebody else, and we can't use that. Now, it's not fair. There's a hearsay exception for anything that you said. So the prosecutor can bring in someone to testify to what you said, and they can lie about it, and it's going to come in. So we're going to be going over this with you. There'll be documents, there'll be video, there'll be certain things we'll be trying to block, certain things we'll be trying to get in that the prosecutor will try to block. And we're going to do everything beforehand to try and know as far ahead as we can what's going to come in, what's not. But there's no guarantee that we're going to know exactly if a piece of evidence is going to be admitted or not when the trial starts. Because like I said at the beginning of all this, a lot of these rules are written like going up on 150 years ago. So what it's designed for is you're in the trial, I go to admit a piece of evidence, and that's where we decide if I can even use it or not. And you're sitting here going, all right, my whole freedom counts on whether this video gets played or not, or if I'm really at risk of losing if they let this person testify, are they going to let them do it? These are big considerations. We've also got to make sure that we've got all of our witnesses there, and we got to get subpoenas out to them, make sure that they're present. And I'm not trying to say anything bad about anybody in your life, but I've just seen this over and over that when push comes to shove, people don't like to go to court. They don't like to get involved. And so be ready for that close person that you really need. All of a sudden, they don't want to be there. Now, we can always subpoena them and make them be there. But when we do that, their testimony tends to not work out. This is going to be a really stressful time. We're going to be making all of our final preparations. What I'm doing is I'm figuring out what I'm going to say at opening, I have three places where I can talk to the jury: the opening statement, the closing statement, which you've probably seen that on Law and Order or whatever. But when we're picking the jury, it's called voir dire, and I get to talk to them there. So I'm trying to think of what theme, what can I say that these average people can relate to that I know is going to come into the evidence? And then we got to think about how we present this stuff. And then we're going to run some practice scenarios with you and get you ready for testifying. Because when you testify with me, it'll be easy. I'm asking you questions. You're going to tell the jury and you're going to explain your side of things. But then the prosecutor is going to get up there, and they're trained just like me. They're going to cross-examine you pretty hard. Then we're going to get ready for that. There's a lot of things you're not going to see, like we have to get these jury instructions ready. And then usually there's a lot of last second negotiations and communications between the prosecutor and the judge. So like give you an example, one happened to me recently. We got up to the pretrial, seemed pretty mundane. I was like, let's just get a continuance. Judge all of a sudden got mad for no reason. Wanted to hold our feet to the fire with trial in 2 weeks. I was like, all right, well, then we're ready for trial. And I told the prosecutor, drop it to a misdemeanor and we'll take it. Wouldn't do that. And then, okay, well, then we're ready for trial. And then we're moving on, we're getting ready. And then all of a sudden, the court and the prosecutor, they're acting like it's my fault that we're about to have a trial. And then all of a sudden they're calling us every day and they don't want to call a jury and blah, blah, blah. But then at the last second, they dropped it to a misdemeanor. So there's going to be a flurry of activity like that that's going on. You're probably going to go through a roller coaster of emotions. You're probably going to go to bed one night thinking we're going to win everything and then wake up in a cold sweat and we're going to lose it. I don't think that we're ever in a situation where we absolutely cannot take a deal. So if things change and we want to take a last second deal, we probably can. But once we're getting up on that cusp of trial, myself and my lawyers, we're switched over. We're ready to do this. So whether it's a jury trial or a bench trial, it's going to be highly stressful, and that's probably where it's going to start hitting you emotionally. You might lose your freedom over all this, but we'll have you ready for it. And if we're doing the trial, we're going to put our absolute best foot forward. And then if for some reason it goes against us, you can't file the appeal. And so what we do, what every lawyer does, if we take it to trial and we lose it, we will file that notice of appeal to preserve your right. Then we'll visit with you if you actually want us to do the appeal or not. But we'll make sure it's there so you can have it. But on appeal, they can only look at the record at the trial to see if there was a mistake. You don't get just a free shot to redo it. So it's very, very serious going to trial. That's the end of the station, one way or the other. And you're either walking out of there or going to be a guest of the state. But by that point, you're going to know everything about the case. We'll have evaluated all the evidence, all the risk, and we're going to be in the best situation to make the best case to get you out of it. But that's the gist of how a trial works. It'll be some late nights, a lot of activity, very stressful, but that's what all of this is built into. We'll be ready. Thanks.